Welcome to Legal Guidelines Prep for Florida Law Enforcement Officers. This is Deputy Z, and today I will be covering arrests, both warrant and warrantless, misdemeanor exceptions, and probable cause. An arrest is the apprehension or taken into custody of an alleged offender in order that he may be brought into the proper court to answer for a crime. See Fuston v. State. The elements of arrest are 1. A purpose and intent to effect arrest under real or perceived authority. 2. An actual or constructive seizure or detention of a person by an arresting officer. 3. Communication by the arresting officer to the person arrested of their intention or purpose to effect arrest. And 4. The understanding of the person arrested that it is the intention of the arresting officer to arrest and detain them. See Clark v. State. All arrests must be predicated upon a probable cause belief that a crime has been committed and the subject in custody is the person who committed the crime. The arresting officers must be able to clearly articulate the facts that led him or her to believe that a crime was committed by the individual arrested. The arrest affidavit must contain facts and details about the crime. Specifically, it must contain the elements of the crime charged. The laws of arrest are governed by Florida Statute Section 901. There are two forms of arrest: an arrest with a warrant and without a warrant. We will start with arrest with a warrant. An arrest warrant is a court order authorizing and requiring law enforcement to take a named individual into custody to answer for specified crimes. An officer making an arrest pursuant to a warrant must inform the arrestee of the cause of arrest and that a warrant has been issued unless the individual flees, forcibly resists the officer, or is given the information will jeopardize the arrest. The right to be free from unreasonable intrusion into one's home is one of the most strictly guarded rights within the law. Absent exigent circumstances or consent, officers cannot enter a home without a warrant. An arrest warrant authorizes law enforcement to enter a residence when they have reasonable grounds to believe the residence is the actual residence of the subject of the warrant and a reasonable belief that the subject of the warrant is within the residence. See VPS v. State. However, an arrest warrant alone will not authorize law enforcement to enter a third-party residence in which the subject of the warrant does not actually reside. In such cases, law enforcement officers are required to obtain a search warrant for the third-party residence. See Stiegel v. United States. To force entry into a building or property where the subject of an arrest warrant is or is reasonably believed to be, an officer must first be denied entry after having announced his or her authority and purpose to make an arrest by warrant. The need to announce is waived when 1. The person within already knows of the officer's authority and purpose. 2. The officer has a justified belief that persons within are in imminent peril of bodily harm. 3. Announcing would increase peril to the officer. Or 4. The individuals within are engaged in conduct which justify a belief that an escape or destruction of evidence is being attempted. See Benefield v. State. A capias is a court order authorizing an arrest for failure to appear in court. These warrants are referred to as bench warrants for misdemeanors, alias capias for felonies, or pickup orders for juvenile cases. An arrest without a warrant is a law enforcement officer may arrest a person without a warrant under the following circumstances. The person has committed a felony or misdemeanor or violated a municipal or county ordinance in the presence of the officer. An arrest for the commission of a misdemeanor or the violation of a municipal or county ordinance shall be made immediately or in fresh pursuit. A felony has been committed and the officer reasonably believes that the person committed it. The officer reasonably believes that a felony has been or is being committed and that the person to be arrested has committed or is committing it. A warrant for the arrest has been issued and is held by another peace officer for execution. A violation of Chapter 316 has been committed in the presence of the officer. Such an arrest may be made immediately or in fresh pursuit. Upon review of a signed affidavit provided to an officer by a law enforcement officer of the United States government or United States military law enforcement officer from which the officer determines he or she has probable cause to believe that a misdemeanor has been committed in the presence of the United States law enforcement officer or the United States military law enforcement officer on federal military property over which the state has maintained exclusive jurisdiction for such a misdemeanor. Certain specified misdemeanor offenses which allow for arrest without a warrant. See warrantless arrest misdemeanor exception for a list of the misdemeanor exceptions for which an officer may make a warrantless misdemeanor arrest with probable cause. A police officer may make a warrantless arrest if there is probable cause to believe that a felony has been committed and the individual is the perpetrator of the crime. If the crime involved is a misdemeanor, the officer may not ordinarily make a warrantless arrest unless the crime was committed in his or her presence or a statutory exception allows for the warrantless arrest. There are a number of statutory exceptions concerning misdemeanors commonly known as the misdemeanor exceptions. The following list of crimes provide the authority for an officer to make a warrantless misdemeanor arrest without witnessing the elements of the crime. as long as there is probable cause to believe that the crime occurred and the individual to be arrested is the perpetrator of the crime. With animals, there are 5: leaving or dispositing a poison in any common street or in any yard or enclosure not occupied or owned by the perpetrator; cruelty to animals; confinement of animals; violation of livestock transportation requirements; and selling or commingling of animals with contagious diseases without disclosure. We then have assault on specified officers and medical personnel, such as law enforcement officers, firefighters, emergency medical care providers, public transit employees or agents, or other specified officers as set forth in Florida statutes. Battery, child abuse, criminal mischief, disorderly conduct as licensed establishments, domestic violence or dating violence, or injunction for protection against exploitation of domestic violence, possession of a firearm or ammunition while bound by a final injunction, drugs, possession of not more than 20 grams of cannabis, exposure of sexual organs, loitering and prowling, obscene material, racing, street takeover or stunt driving, sexual cyber harassment, stalking, theft from a public lodging establishment or public food service establishment, theft from a retail store or farm, any traffic criminal offense under the provisions of Chapter 316, transit fare evasion, trespass at an airport, trespass from public fairgrounds, trespass from schools, and vessel safety, which is a violation of a safety zone, security zone, regulated navigational area, or naval vessel protection zone, as described in Florida statutes. Now we will go into probable cause. An arrest by a police officer pursuant to a warrant or a warrant exception must always be based on probable cause. The officer must have probable cause to believe that a particular statute has been violated by the subject and that all the elements enumerated in the statute are present. In Florida, probable cause for an arrest exists where the facts and circumstances within an officer's knowledge is sufficient to warrant a reasonable person in the belief that an offense has been or is being committed. See Jenkins v. State. The determination of probable cause for an arrest is a layered concept wherein the officer must use all of the factors and circumstances available to them at the time, also known as the totality of circumstances. Probable cause to make an arrest is a lesser standard than that required for a conviction, which is proof beyond a reasonable doubt. The only factors which will be reviewed to determine whether an officer has probable cause for an arrest are those factors known to the officer pre-arrest. Pre-arrest factors establishing probable cause may include the officer's observations, as well as those of fellow officers, information received from citizens, witnesses, informants, victims, etc., and physical evidence. The pre-arrest factors establishing probable cause are the most important because these factors must establish probable cause prior to making the formal arrest. While post-arrest factors may be used in the subsequent determination of proof beyond reasonable doubt, probable cause for the initial arrest must exist at the time of the arrest. Some guidelines for probable cause. Once an officer has determined that probable cause exists and an arrest has been made, it is equally important that the documentation of the incident and circumstances be as complete and accurate as possible. The initial evaluation of whether probable cause for the arrest exists will be made by a judge or an assistant state attorney based on a review of the arrest affidavit. Therefore, it is critical that this document contain all the necessary elements to establish probable cause. Officers should document all facts and evidence that will lead the reviewer to the conclusion that probable cause exists for the arrest. Facts supporting all elements of the charged offense shall be covered. Avoid using broad, conclusionary statements. It is also encouraged for officers to provide details as to how or why the officer encountered the suspect in the first place. A detailed arrest affidavit and accompanying police report may also serve to refresh an officer's memory if court proceedings take place after an extended period of time. There could be serious consequences for both the officer and the department if it is determined that there was no probable cause for an arrest. Charges against the defendant will be dismissed, evidence may be suppressed, the officer and department may be targeted for civil lawsuits, and the officer may face criminal charges. Now we will talk about the release of an arrestee. During the course of an investigation, information may come to light subsequent to the arrest that affects the probable cause determination. Probable cause to believe that the defendant committed the crime may evaporate in light of new information uncovered in the subsequent investigation. This may occur shortly after the arrest or after an excluded period of time. Upon making a determination that probable cause for an arrest no longer exists, which, depending on the circumstances, may require consultation with the prosecutor or in-house counsel, the arrestee should be immediately released. The officer should make every effort to return the individual to his or her pre-arrest state by transporting the arrestee to the original place of detention, releasing all personal property impounded, etc. Accordingly, the arrestee should be given an explanation regarding the circumstances relating to his or her release. Caution should be exercised in the release of information if the investigation is continuing, so as not to divulge any active criminal investigative information. Individuals should be assisted in recovering their vehicle if one has been towed and given any other reasonable assistance. The subsequent release of an arrestee based on new information, which negates probable cause, does not mean that the original arrest was without probable cause or was illegal. The initial arrest still retains its legal validity based on the facts known to the officer at the time of the arrest. In all such cases, a detailed report must be prepared containing all pertinent information. And that concludes our topic for the day. Deputy Z signing off. Catch you guys on the next video.